continue your case, answer motion. If you would like to speak with me, the Assistant District Attorney, before you make a decision as to what you're going to do with your case today, then answer open. If you are not going to answer in one of those ways, you need to answer with your plea, and that will be either guilty or not guilty. If you're a witness or a victim in a matter, I will not call your name, but the name of the person charged. When you hear that person's name, please answer witness present. Also, too, we ask that if you are interested in mediating your case today, when you hear your name or the name of the person charged, please respond with mediation, and that will be noted accordingly.
Thank you, Madam DA. Mediation has been recognized as a tool. Did you want to say something, Mr. Campbell, on behalf of mediation?
Yes, sir. If I may approach and address the ladies and gentlemen who are waiting in the courtroom, what is mediation? It's an alternative to having trial. It's an alternative to litigation, and there are benefits to every single person in this room. We don't have today cases involving law enforcement officers, nobody who was neutral that was an eyewitness. We have also cases that would probably benefit by people talking to each other, not just cases where there was a lack of communication. And the third thing that every single case shares as a common denominator, Your Honor, is the fact that all of us would benefit by having professional mediation, where a neutral person listens to you and helps you reach a resolution this afternoon, today, that you can live with. So when the time comes, please tell the Assistant District Attorney, if you're the state's witness or the victim in the situation, that you would like to consider mediation. And as you know, if you do get involved with mediation, it doesn't mean that you still cannot have a trial. Judge Morgan can still hear the evidence and then make a ruling according to law. But we do hope you'll take advantage of this situation, save some money over the cost of court, and be involved in mediation, which is an alternative to trial. Thank you.
Thank you, Mr. Campbell. As Mr. Campbell has said, there is the availability of mediation afforded by him and his expert team of trained mediators to attempt to resolve differences that those of you that have cases here may have. There is a significant backlog of cases, of course, which tend to have this courtroom to have situations where not all cases may be reached. So you can have a more immediate resolution of your matter if you decide to go to mediation with your matter and have a successful outcome related to that. Similarly, it will be your last opportunity to have any input in the resolution of your matter, because in fact, if you cannot mediate the matter, then that means that the matter will be for the court to resolve, and the court will be bound by the evidence as well as what the outcomes must be as dictated by the legislature in terms of the authorized legal outcomes. So you may have more input and come to whatever resolution you may feel is appropriate for your circumstances between and among those parties involved specifically. But if you cannot do that, then it will be to the court to get an outcome that the law would dictate should occur. So again, contemplate mediation is a valuable tool to relieve court docket congestion and also allow parties to have a reasonable opportunity to have significant input into the outcomes of their respective cases. Please consider mediation. Thank you. There's one matter that we have, that's the Vicky Bunch case.
Yes, Your Honor, and that unfortunately is going to be the state's motion. I've given the witness until second count of call to be present. The witness is not. That's correct, Your Honor. It is for trial.
All right.
And my client is present.
Ron, you missed your comment.
Do this.
Yeah.
1999 case, remarked last for the state. This will be determination made by my colleague and last time that we may further continue with the
It's not just your face. Okay. I
Madam D, is this the state's motion by chance?
Your Honor, I believe it would have to be since the state's witness is not presence,
Mr. Watson, Mr. Pappas, come forward, please. Hello, Mr. Watson. My name is Ryan Campbell. Mr. Pappas, I'm Ryan Campbell. Come on in, folks.
Yeah.
If you take a seat in the orange seat and the black seat, that makes you gentlemen, have a seat, please. Fellas, once again, my name is Ron Campbell, and I'm here to explore the possibilities of mediation of your situation. Gentlemen, before we begin the mediation, I'd like to talk with you about some of the basic rules that we're going to follow. First of all, I want to listen to each one of you, and each one of you will have an opportunity to speak, but I ask that you speak without interrupting the other party. After we've had a chance to talk each individually, then we might, the three of us, discuss something and see what kind of a resolution might be available. Also, before we begin mediation, there are three words that start with the letter C that I want to share with you. First and foremost is the letter C, standing for confidence. I cannot tell any of your secrets. Anything that we talk about will stay right in this room. I cannot go out in the courtroom. I cannot be subpoenaed by either one of you as a witness. So what we're talking about stays right here. Everything is in absolute confidence. Second of all, the letter C stands for court. I'm not the judge. I'm not here to say one person is good, one person is bad, that you're right and that you're wrong. We're here, the three of us, to see if there is something we can do to reach a appropriate resolution. Of course, a resolution where the terms are written down. The third C stands for the word cost. As you know, in this particular courtroom, there is a cost of court for criminal matters that has been mandated by the state legislature. In lieu of paying that money, you could save $40 in the cost of mediation, which is $60. Fellas, do you have any problem with the cost of court? Do you have any questions so far about the basic procedure of mediation? If none appearing, Mr. Watson, I'm going to ask you both to fill out a form. If you would please print your name, your address, your telephone number, and make it in large printing. I've got old eyes, I've got to be able to see. Mr. Pappas, this is permission to mediate. Would you please also sign your name and print your name? And this again summarizes what we've talked about. As soon as we've done this paperwork, we can go ahead and begin with the process of mediation. All right, and would you print your name, Mr. Pappas, please? All righty, good. And we'll just share pieces of paper. You both print, sign your name, fill out the information, please. Okay. That's fine. Now, let's begin. I'm going to ask Mr. Pappas, what brought us to court today?